The income tax authorities have lately started reopening cases where the assessments had already been completed under Section 59(1) of the Information Technology FIRSTA Ordinance under the Self-Assessment Scheme. This is likely to cause inconvenience to the taxpayers and discourage new taxpayers. First up, according to reports available, the income tax officers are these days issuing notices under Section 65 of the Income Tax Ordinance 1979 to reopen the already complete assessments of taxpayers. First up, the reason given for this action is that higher authorities have issued instructions for the same. First up, the ground for reopening assessments is concealment made at the time of proceedings before the income tax officer. For instance, the assessee may not have declared certain assets owned by him, or any profit gain or any investment made by him in the wealth statement of that relevant year, and the income tax officer, after completion of assessment, may detect the same or receives information from certain sources and has definite documentary evidence in his hand. First up, in such cases, the action under Section 65 of the Ordinance for Reopening is justified. First up, but for this he has to take the prior approval of the inspecting assistant commissioner of income tax, commissioner of income tax. First up, I know of cases where the income tax officer has sought permission for reopening under Section 65 from the Commissioner of Income Tax, and it has been granted without going through the merits and demerits of the case.